The case is pending before the Supreme Court right now on an emergency application from the Trump administration because the lower courts ruled in Lisa Cook's favor, allowing her to continue to serve, as you said, while her case plays out. The government has asked the Supreme Court to undo that and to remove her while the litigation plays out. So we expect the ruling could come at any time in the next days or weeks.
Doesn't the Supreme Court have a day job? Like, don't they have a docket that they've decided which cases they're going to look at? Yet, it's seemingly on a weekly basis, something from the Trump administration bubbles up to the Supreme Court. Don't they have the ability to say, hey, guys, we're busy. Take care of your own business?
Well, I mean, what you're referring to is what's called the shadow docket, which is these emergency applications that come to the Supreme Court. And I think it underscores sort of the just how quickly the Trump administration has been moving on a lot of things, issuing so many executive orders more than any other administration. And as a result, a lot of those get challenged. And because things have to get unwound on an emergency basis, according to the challengers, that's why so many of these cases get placed on the shadow docket, because they are of an emergency nature.
Right. Well, there is an urgency here when it comes to Lisa Cook and her status on the Federal Reserve. Her attorneys have urged the Supreme Court to let her stay on the job, warning that even a temporary removal risks chaos and disruption in financial markets. Is that something that's going to factor into the Supreme Court justices' ruling or thinking about this?
Well, it's interesting because I put out a note last week saying that I think Lisa Cook already won round one because Justice Roberts could have issued an emergency stay, meaning he could have put the lower court's rulings on hold immediately, as he has done with other cases where commissioners of other agencies have been terminated and challenged their terminations. He didn't do that here, which in my mind suggests he thinks, maybe this can wait a little because he referred it to the other justices. And it's also notable that the Trump administration didn't rush to the Supreme Court as soon as the D.C. Circuit ruled in Lisa Cook's favor. They could have gone to the Supreme Court the night before the September 16th Federal Reserve FOMC meeting. They didn't do that, and Lisa Cook has pointed to that as well in support of her argument that this doesn't have to be rushed.
How is this Supreme Court ruling these days? Are they ruling along party lines? Is there evidence that they are, in fact, neutral, indifferent? Do we have any? What's the evidence suggest?
Yeah, I think it depends on the issue. In a lot of the cases where these agency commissioners have been terminated, you do see the rulings really falling along ideological lines, with Democrats supporting independent agencies and saying that the president can't just fire these commissioners at will and that the for-cause removal has to mean something. The Supreme Court, for the most part, has ruled against that argument and said that the for-cause removal restriction is unconstitutional because these agencies fall under the executive branch. With the Federal Reserve, we sort of see that not exactly happening, and we saw that in the May 2025 Supreme Court ruling, which sort of distinguished the Fed from these other agencies. So I think with this Federal Reserve ruling that we expect from the Supreme Court, it's not going to fall exactly along ideological lines.
So whose commentary would you be listening for, would you be watching for when the Supreme Court does rule on Lisa Cook?
So it's interesting because you're not going to get oral argument in this case. Part of the problem, critics would say, with the shadow docket is, you don't get the fulsome written arguments, you don't get an oral argument, you don't really get to expand on all the issues in the case. So we're not going to have the luxury of an oral argument like we usually do, where you can maybe see where some of the justices are leaning. When they issued the opinion, you may not even know which justices subscribe to which parts of the opinion. So it's a little, that's the criticism.
Everything's abbreviated.
Exactly, and that's the problem, critics would say, with the shadow docket.
So, critics just looking at this case would say this is purely political. This is a president going after someone who he does not favor over a nitpick type thing from years and years ago. Can't the Supreme Court see that as well and say, hey guys, this isn't a business we're in, playing your political games?
Well, they will stick, I think, to the legal arguments. Those political arguments do come up in some of the friend of the court amicus briefs that get filed with the Supreme Court, arguing one way or the other. And that can give the Supreme Court some context as to why some of the issues are important, although they already know that, I'm sure. But for the most part, they'll stick to the legal arguments.
Yeah, I believe the former Federal Reserve chiefs, as well as former Treasury secretaries, all those who are still living, except Steve Mnuchin, signed a Friends of the Amicus brief to the Supreme Court urging for an independent Fed. Will that have any sway? I mean, the Supreme Court doesn't need to act on that at all, right?
Right. They'll read those, and those will inform the justice's opinion. And sometimes they'll cite to those amicus briefs. But for the most part, again, they'll stick to the legal arguments. But those amicus briefs from, former Federal Reserve governors and Treasury secretaries on both sides of the aisle really underscores why the Federal Reserve is different from these other agencies, which I think the Supreme Court has already recognized.